Platinum founder Brian Sedella. Learn about what's hot and what's not with both surgical and non-surgical medical aesthetics and skin and body rejuvenation treatments for men and women. The opinions expressed on the preceding sponsored program were strictly those of its hosts, guests, and callers, and not necessarily those of the station, its staff, management, or sponsors. The content of the following program, including all statements from the host and guests, is to provide general information and commentary about the law. Under no circumstances does any statement made by a host or guest to a caller or listener constitute legal advice or the formation of an attorney-client relationship, and the material from this program should not be viewed as a substitute for personal consultation with an attorney. Welcome to Talk Legal with Jeff Van Treese, who brings you all the latest news in the legal world. Jeff will be discussing a variety of legal topics with experts in the field. If you would like to ask a question or share a story on the air, please call toll-free 888-565-1470. Once again, that's 888-565-1470. Now, let's talk legal with Jeff Van Treese.
Good evening and welcome to another edition of Talk Legal. I'm your host, Jeff Van Treese. I'm an attorney with the law firm Altman, Flynn & Kubler, where we specialize in intellectual property law. Would like to thank all of our listeners, both those of you tuning in on the AM dial as well as those watching online. On this special edition of Talk Legal, I will be hosting a debate regarding the DUI flyer that was originally featured on this program in November of last year. The DUI flyer has been getting a lot of news lately as it was featured on CBS This Morning after there was a viral video that got over 2 million hits on YouTube. The video depicted a driver that puts up a flyer to the window when he arrives at a sobriety checkpoint. The flyer states that the driver wishes to remain silent, wants his lawyer, and that he is going to keep his window rolled up unless he's otherwise ordered to do so. The flyer also states that he would comply with all clearly stated lawful orders. In this video, the driver is waved on by the police officer at the checkpoint and is subsequently told to have a nice day. This video has sparked a storm of controversy about the constitutionality of DUI checkpoints and the options that drivers have with respect to not interacting with police officers at these checkpoints. With me in studio this evening to discuss this issue is the creator of the DUI flyer, Warren Redlich. He is a criminal defense attorney and practices in Boca Raton, Florida, and he's appeared on this show a few times before. He's also the author of Fair DUI, How to Stay Sane in a World Gone Mad. Also joining us this evening via telephone is attorney David Weinstein. He's a criminal defense attorney and former prosecutor from Miami. Both gentlemen appeared on the CBS This Morning segment and offered opposing viewpoints on the use of the DUI flyer. I should also add that Warren has appeared on the Dr. Drew show recently regarding the DUI flyer, and tomorrow Warren will be on Fox and Friends discussing the DUI flyer as well. So, Warren, let me start with you. If you could explain to our listeners what is the DUI flyer and why did you create it?
Sure. The purpose of the DUI flyer is basically you're an innocent person. Maybe you've had a glass of wine or two at dinner, and you come into a police checkpoint or you're stopped for a traffic violation. And I get questioned all the time by my clients and my friends, what should I do if the police say this? What should I do if the police say that? And the idea is to protect yourself from some of the common mistakes both innocent and guilty people make when they have that police encounter. Number one, you don't want them to smell inside the car because a police officer may smell alcohol or what they call an alcoholic beverage. Sometimes it's true, sometimes police will make that up, and you have to be careful, or they will imagine they smell it or whatever it is. They're trained to write down that they smelled it. The next thing that they're looking for is whether your speech is slurred or your speech is impaired. And my own experience is that police will often claim someone's speech is slurred or impaired when it's clearly not on video. Or my favorite example is the client I had from Japan, where the police said his speech was impaired, and I have no idea how the officer could tell. So the idea is that by using this flyer, keeping your window up, the police officer cannot claim he smells alcohol from the vehicle, and if you don't speak, he can't claim your speech is slurred, and you're taking away some of the things that they're trained to use to justify taking the investigation further. And to be clear, the flyer says, I remain silent, no searches, I want my lawyer, and then it has some instructions in red below that to explain to the police further details. But those three things are large because they're the Fourth, Fifth, and Sixth Amendments, not an order.
And of course, one of the important things that jumped out at me on the flyer is it also says that the driver will comply with all clearly stated lawful orders. And so you're not actually refusing to open your window. You're simply saying that you won't do it unless you're ordered to do so.
Yeah, I think there's an important, it's one of the things I've noticed in the media hubbub that's followed is people don't understand the difference between a request and an order. And the police officer may not understand, and the judge and the prosecutor, the difference between a request and an order. If you roll down your window voluntarily, police officers coming up to your car or you're pulled into a checkpoint and you roll it down automatically without being asked, then you voluntarily roll down your window and you've waived any challenge to the Fourth Amendment of being forced to roll down your window. If you wait until the police officer, you do this in a checkpoint or in a traffic stop, the police officer has a decision to make. And one of the things I like about this is it makes the police officer think. And police officers, some people don't like police officers thinking, but as a defendant, as a suspect, you want them thinking. If the police officer decides to wave you on, great. If the police officer orders you to roll down your window, and it's a clearly stated order, not would you please roll down your window, that's not an order. They say roll down your window or else. Roll down your window, I'll smash it in. They use colorful language, aggressive language, and it's clear that it's been an order rather than voluntary. Then most people should roll down their window unless you're looking to make a great YouTube video and get a great civil rights lawsuit. And it would be a great excessive force lawsuit if it happened. But for most people, you don't want that. You don't want glass in your eyes. You don't want a police officer forcefully dragging you out of your car. At that point, you probably should roll down the window once it's clearly been an order. And from then on, your Fourth Amendment rights are further protected because the police officer is now going to have to justify why he gave you that order. What was the probable cause or other rationale behind forcing you to roll down your window? And that's going to be a challenge for that police officer, especially in a checkpoint.
So I'd like to see it. Is David Weinstein there? He's joining us by phone. David, can you hear me? Looks like we haven't connected with David yet.
Try again.
Can you hear me now?
Yes, I can. David, thank you so much for joining us. I have criminal defense attorney and former prosecutor David Weinstein on the line. Hopefully you've been able to listen in so far. I was wondering if you could give our listeners your take on the DUI flyer and the appropriateness of using it at a sobriety checkpoint.
I have been able to listen in thus far, and while I admire Warren's efforts to protect everyone's Fourth, Fifth, and Sixth Amendment rights, I think that we need to remember that we're talking about a privilege here and not a right. The privilege that we're talking about is your privilege to drive on the roads, in this case, of the state of Florida. If everybody wants to take out their wallet and pull out your driver's license, you'll notice that on the back of your driver's license, when you obtain this privilege by passing a test and by giving permission, that you realize that you've also given them permission to require you to participate in some roadside tests and as well as provide a breath sample if required. And in refusing to do so may place yourself in some other jeopardy. And in exchange for giving up that right, you get the privilege to drive on the road. The other thing you get with this privilege is that you're going to, in some circumstances, be slightly inconvenienced by a police officer who's complying with the requirements that have been set forth by both the Florida Supreme Court and the U.S. Supreme Court that allow these roadside sobriety checkpoints to exist. The other thing that you need to remember is that when people are given instructions, they often don't follow the instructions, and sometimes they take them a little bit too far. One of the instructions that Warren is giving people is to put this flyer up against their window and to display their license. Whether intentionally or unintentionally, in July of last year, a change was made to 322.15, and where it used to say that you were required to display your license when you were in a situation like a roadside sobriety checkpoint, it now requires you to present or submit your license. We're lawyers, and part of our job is to parse words. So while I would think that putting your license up against the window and allowing an officer to observe it would be displaying your license, I'm not so sure that that equals presenting or submitting, because that same statute allows an officer to examine the license, make sure that it's you on the license, that it's not obliterated, that you are driving with a valid and not an expired license. And part of the other reason why they've amended the statute is that people don't like to carry licenses around with them. We're moving into an age where they're going to allow us to digitally download our driver's licenses and have them on our smartphones. So we will have to present or submit to the officer the smartphone that will allow the officer to take a look. And again, while I admire Warren's effort to protect our Fourth, Fifth, and Sixth Amendment rights, I think the small intrusion that's taking place here, and it's not every car that's stopped at these checkpoints. It's a specific car in the line, and again, if you were in the situation, it's a slight inconvenience to present your license. If you have nothing in your car, I don't think that most officers are going to automatically say that you smell of an alcoholic beverage or they smell something else in the car. I think that, in fact, there may be some officers who, either by reputation or by past practice, have a habit of doing that. But if you're in a situation where you have nothing to be concerned about, the slight inconvenience that is presented by actually handing your license to the officer.
David, I just want to ask you, because there's some versions of the video where people put their license, their registration, and the flyer in a bag, and then they hang it outside their window as opposed to pressing it up against the window. Would that satisfy, in your opinion, the new changes to the law that require you to produce these documents?
By the way, that is why that particular driver in that video did that. We talked about this on the phone before he went out that night. My view, and we can talk about that, is that present includes, definitions of present include show. And as David said, the purpose was actually the smartphones, not, my flyer wasn't in the public consciousness when they made the change. But that is exactly why he put the flyer out in the Ziploc bag like that. So, David, what do you think of that?
Oh, I think that certainly satisfies the requirement, but along the lines of something that Warren said this morning during the piece that aired on CBS News this morning, people who have been drinking and driving aren't going to be able to comply with even a small request like that. Plus, the amount of effort that you're going to have to put together to have the baggie in the car, to have a piece of string together, to get your license and registration out, along with the placard, put it in the bag, put it out the window. Quite frankly, you would have been better off to just roll your window down and hand the license over, wait for the officer to look, get it back to you, and proceed on your way.
Yeah, I actually agree. And I think it's going to be difficult for drivers to do the Ziploc bag approach. I think it's unreasonable to expect them to do that. Also, I've seen an argument that it could be considered an equipment violation. So I personally don't like the Ziploc bag approach. I like my approach better, and I think there's no definition in the statute of present or submit, and there are dictionary definitions of present that include show. So I think that's okay. But did you need something else?
No, actually, we're going to be skipping our commercial break today because we have so much content to get through. I wanted to ask both gentlemen, what would you say to a potential client that, let's say, has had one drink, they've had one glass of wine, in all likelihood they're probably not over the legal limit for blood alcohol content. What would you say to someone like that? Because that's what this flyer, to a large extent, might be helpful for, is if somebody that might either have had a drink or they may have alcohol on their breath, but they're actually not drunk, and at least legally drunk, and they don't want to go to jail.
Can I frame that question a little better for David? David, your client's had 2 glasses of wine, he's sober, and he pulls into a checkpoint. Don't say he shouldn't drink and drive. Don't say he should turn around before the checkpoint. He's already in the checkpoint. What's your advice to that client to do in the checkpoint now?
Well, you've taken away my 2 biggest pieces of advice.
Yeah, but it's too late for that. That's, the whole point.
Well, no, the whole point is these checkpoints don't prop up out of nowhere. You know where the checkpoint is. They have to warn you ahead of time. And as far as the client who's done that, well, you know what? Then they've gone against the advice I would have given them to begin with. You roll your window down, you show the license to the officer, you let him make whatever observations he's going to make, and then at that point in time, If he observes or believes that he smells something on your breath, there are additional questions he's going to ask you. If you're not under the influence, which is what the key is here, DUI stands for driving under the influence. It doesn't stand for you can't have a drink and drive. You can engage with the officer. You can go through whatever test he wants to give you. And if you're not under the influence, you're going to do just fine.
You don't think that there are police officers who would smell the wine and leap to the conclusion, and then maybe you have somebody who's Hispanic or from another, or redneck or whatever, and they decide the speech is slurred and they're wrong? I mean, I don't know how many drunk driving cases you've handled. I've seen a lot of cases where people who are clearly sober on video and the police officers insist they had slurred speech. I've seen cases where people blow a 0.00 and the police officers wrote down in their paperwork that they smelled alcohol. Do you agree that innocent people sometimes get arrested?
I absolutely agree that innocent people sometimes get arrested. And I think that's why we are here as lawyers, to protect these people. But by the same token that you're giving examples of officers who are going to routinely write down that they smell an alcoholic beverage, that they say that there's a slurred speech, I think if you canvass the rest of the officers, you're going to find quite a few who are not going to do that and who are going to take a situation, evaluate it for the truth of the matter, and put forward the truth as to what happened, which was that this person was not under the influence.
So I think that this is an issue of, are the checkpoints reliable in terms of not arresting people that are not impaired over the limit, but they may have had one drink? And I think that my two guests disagree on that subject.
I think David's approach is a very good way to get arrested, and I think my approach, one of the responses I've heard from defense lawyers, because not everybody, David, by the way, is in the majority, that most defense lawyers that I've seen comment on this agree with David that this is not a good approach for various reasons. The problem is that I haven't heard a better approach, and my experience is that an awful lot of people get arrested wrongly, and we've done this that I'm aware of. We've gone through 8 checkpoints that have been on video, and we've succeeded every time. So, the day's going to come when it doesn't work. My friends, I've told my friends to stop going through checkpoints. We have other things we're pursuing, but they don't listen to me. They're going to keep doing them. So sooner or later, we're going to cross a checkpoint where it's not going to work, and then we're going to get to test it out in court. But I think David's answer gets you arrested.
Well,
David, what do you think about that?
Well, I want to go back to an earlier subject that we talked about. I think that in order to push the envelope to the limit here, which is what Warren's doing, if somebody's going to get arrested, whether they've had a drink or no drink, and they've decided to put the flyer and the license up against the window or swing it outside the window, and if they put it up against the window and the officer who's going to have a subjective impression as to what happened is going to say you're not complying, and he's going to ask them to roll down the window, and they've listened to Warren. They say, well, I don't have to roll down the window. You're making me roll down the window. Okay, now I'll roll down the window. And at some point it'll escalate, and then we'll find that case in front of a judge who's going to have to decide whether or not the words present or submit equal the same thing as display. And we don't know the answer for sure. What we do know is that person who's now taken Warren's advice is probably going to spend the night or a couple hours in jail, whether they're correct or incorrect in what they've done. So in that situation, the same thing that Warren's trying to prevent, which is innocent people from being arrested and having to go through the court system, they're going to end up in the court system. I think that the people who are out having a few drinks and decide that they want to drive against the advice of most of us, and they're going to roll through that checkpoint, well, they're not taking their chances. And whether they encounter a subjective police officer who's going to be reasonable, who's going to evaluate the situation and look at the person for what they really are versus I just need another arrest, is a question that we're not going to know the answer to.
I think this brings up a point, which is that we're talking about a class of people that the public is just not very sympathetic to. We're talking about people that have had a drink or two that are under the legal limit, but of course they're out driving. They don't know that they're under the limit. They don't know that whether they might be over the limit. And so, like you said, they're not taking the advice. They're not acting with any degree of common sense, but they still might be innocent of the crime of driving under the influence because they're still under that legal limit. Do you think that plays any role in how this is viewed? And I'd like to pose that to both of my
I'm not sure I
guests.
understand your question.
I'm saying that we're talking about people. The way that this has been portrayed has been that some people have been unsympathetic to put to this flyer being put up to the window. And like you said, a lot of it's to protect people that might be innocent of the crime of DUI, but they've had a few drinks.
Yeah, and let's be clear. David and I agree. You shouldn't drive after I think David agrees with me on this. You shouldn't drive a car after a single drink, not necessarily because you're a danger to the public, but because you're a danger to yourself and the legal system. Am I getting you about right, David?
Yeah, I also think that depending upon, who you are, you might be a danger to yourself. One drink, for me, depending upon my height and weight, is different than one drink for somebody else. It also depends how much you've had to eat when you get out and drive after you've had the drink. Whether or not, as you and I are both aware, how much of the alcohol's now gone through your system, how much you've metabolized. There's a lot of factors to go in here. But, to answer the original question that Jeff had, as I understood it, I think that the class of people who tend to want to see if they can use this route versus just stopping and putting their driver's license out the window, they are viewed as an unsympathetic group to most people. And I think that the public opinion that swings against this comes from a lot of people who believe that people who are drinking and driving should have to pay the price for drinking and driving because they're causing accidents and they're causing injury and damage to people who are on the road. And I'm not saying that those people are not a vocal majority or minority, nor am I sure if the people who are following Warren's advice and are going through these checkpoints to test the system and see what's there, whether there are a lot of people who are innocent people who really have nothing to fear and just want to push the envelope and are thus just making a lot of noise about it, and in fact they really are in a minority, and that most people really don't have a problem with this light intrusion and have faith in the legal system that at the end of the day that the truth will prevail and that innocent people aren't going to be sentenced for a DUI when they're not under the influence.
Do you believe that? You believe the system is fair?
I do. Having been on both sides of the system, I really do think that there are exceptions to the rule, and I think that you're going to find a bad egg on both sides of the equation. But I think part and parcel and in most parts of the system is fair, and that, if put to a jury, the jurors usually come back with the right decision, and that most judges are cognizant of the law and act as impartial magistrates. And, I don't think that every prosecutor's sole objective in life is to put a defendant in jail when they come up in front of them. I think there are people like that, but I think for the most part that people are interested in the truth prevailing.
I have to move on because we have just a few minutes left. I'd like to ask Warren, what do you think about, you get pulled over and you're going to definitely probably aggravate the cop that pulls you over and sees the sign. What if he just decides to go back to his car and write as many tickets as he possibly can? And
I'd rather take those tickets than a DUI arrest. And I think I want to come back to something that David just said, though. When you get arrested, when a police officer makes the judgment that he thinks you're impaired, they take you, in Palm Beach County, they take you to Gun Club Road, except for certain cities. They take you to Gun Club Road and they have you blow on a breath machine.
That's a local jail.
That's the jail in Palm Beach County. They don't take you to the jail, they take you to the facility and they have you blow on a machine. If you blow a legal number, they still charge you. They still put your mugshot on the internet. I don't know if that happens in Miami-Dade. David, do you know?
Yeah, no, it's not. It's not a gun club. It's another, other facility. They take you in, and then, you've now given them a reading that's a legal reading. So now they have to determine whether or not they're going to arrest you based on what else they've observed.
No, you've already been arrested because you've been taken to the station. But in Palm Beach County, they charge anyone who's brought into the station. They could blow a 0.00. They still file the charge. I've seen it multiple times. I don't know whether that's true throughout Florida. I think it is. I think it's standard throughout Florida. Once you're brought into the station, it doesn't matter what you blow. They're going to file the charge. But you can tell me, have you seen that in Miami-Dade? Are they ever let somebody go in Miami-Dade if they blow a legal number?
I don't want to say it's never happened. I think it's rare that it happens. I think it's more common, exactly what you're describing. If they're taking you in, you're going to spend the evening until you bond out.
Right. So that's my point. One of my points is even if you succeed, as David said, and my experience is a lot of people can't afford us. I'm sure David's not free. I'm not free either. A lot of people can't afford us. They may choose the wrong lawyer. But the practical reality is the minute that they take you into the station, whether you blow a legal number or not, your mugshot goes on the internet and your neighbors all think you're a drunk. And you can't erase that, even if you win your case.
You know, I'm going to have to end it there. We have just a couple of minutes left. I want to give both of my guests an opportunity to give their contact information out to any of our listeners that might be in need of their services. Warren, if you could tell everyone how they can reach you.
Sure. My name is Warren Redlich. My website that for this purpose is fairdui.org, FAIRDUI.org, and my phone number is 888-RED-LAWYER, 888-RED-LAWYER.
David, if you could give our listeners your contact.
Sure. This is David Weinstein. I have a criminal defense practice down here in Miami, Florida. You can find me at my firm's website. It's an abbreviation for our law firm, CSPAlaw.com. And you can reach me at 305-377-0700.
Great. I'd like to thank both of our guests. This has been a very interesting debate. I'm sure that coverage of this issue is going to continue into the future, and it will definitely affect the landscape of DUI law and the Constitution and the Fourth Amendment. Please tune in next week, Tuesday night, from 6 to 6:30, where my guest will be attorney Jeff Brown, and we'll be discussing the right to die and physician-assisted suicide. This is Jeff Van Treese. Thank you so much for listening. Once again, I'd like to thank my guests, and hopefully see you next week. Have a great evening.
Thank you for listening to Talk Legal with Jeff Van Treese. Tune in next week for more insightful and exciting information about the law. You can contact Jeff by email at jvt2law@gmail.com or give him a call at 561-789-6866. That's 561-789-6866. The content of the preceding program, including all statements from the host and guests, is to provide general information and commentary about the law. Under no circumstances does any statement made by a host or guest to a caller or listener constitute legal advice or the formation of an attorney-client relationship, and the material of this program should not be viewed as a substitute for personal consultation with an attorney. The opinions expressed on the preceding sponsored program were strictly those of its hosts, guests, and callers, and not necessarily those of this station, its staff,